Driving home late, it's quiet, you're thinking about getting inside and relaxing, and suddenly your rearview mirror explodes with red and blue lights. Your stomach drops, your mind starts to race, and in that moment, one question becomes more important than anything else. What are my rights right now? Today we're talking about civil rights, specifically your Fifth Amendment rights during an encounter with law enforcement. I'm not giving you vague answers from a textbook or from an attorney. I'm telling you what I know from 7 years of direct experience working in the field, and I'm backing up this information with research, scholarly articles. Many of you have had encounters like the one I described, and even if you haven't, you almost certainly will at some point in your adult life. This knowledge is your legal armor protection from being taken advantage of in a stressful, high-pressure moment. By the end of this, you'll understand these things: where the Miranda ruling came from, what your civil rights actually are, and what custody and interrogation really mean. To understand your rights, you need to understand the case that created them: Miranda v. Arizona, 1966. In 1963, Ernesto Miranda was arrested in Phoenix, Arizona for kidnapping and raping a young girl. He was identified by the victim, taken into an interrogation room, questioned by two officers, and eventually he signed a confession. But there was one major problem. He was never told he had the right to an attorney, and he was never told he didn't have to speak. That confession was used against him, and he was later convicted. When the case reached the Supreme Court Chief Justice Earl Warren, he made a powerful statement about the Fifth Amendment. He said the case raised questions that went to the roots of American criminal justice, specifically when statements taken during custodial interrogation are actually voluntary if a person doesn't know their rights. This ruling changed American policing forever. It created the requirement for Miranda advisement before custodial interrogation. This is a Miranda card. This is the advisement officers read during custodial interrogations. Here's what it says. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him or her present with you while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish. You can decide at any time to exercise these rights and not answer any questions or make any statements. And finally, do you understand your rights as I have explained them to you? Many people don't realize this, but the Supreme Court never created a single official script. Police departments across the country use slightly different versions, but they must all communicate the same constitutional protections. And to use any statement you make, the state must prove your waiver was knowing, intelligent, and voluntary. In other words, you spoke because you chose to speak, not because pressure, fear, or confusion pushed you into it. Now here's where people get confused. Miranda rights don't apply to every police interaction. They apply only when two things happen: custody and interrogation. The Supreme Court says a person is in custody when they're either under formal arrest or when their freedom of movement is restricted to a degree. It is not about what the officer thinks. It's about whether a reasonable person would feel free to end the encounter and leave. Courts consider the totality of the circumstances, such as, are you wearing handcuffs? How many officers are present? Where is the interaction happening? Are you in a public place like a park or in front of a grocery store? Or are you sitting in the back of a police car? Interrogation is not just direct questioning either. It includes any words or actions by an officer that are reasonably likely to elicit an incriminating response. The United States v. Richardson states, a government officer must apprise a suspect of his rights when two events occur: the individual is in custody and the officer interrogates that individual. If both of those two factors are not present, Miranda is not legally required. So today we covered the origins of Miranda, your civil rights under the ruling, and what custody and interrogation really mean. But remember, you were sitting in your car when fear wanted to take over. But knowledge, your knowledge, levels the playing field. You can't control everything about the situation, but you can control what you say, whether you speak at all, and whether your rights are protected. Chief Justice Warren said, unless adequate protective devices are employed, no statement obtained from the defendant can truly be the product of his free choice. That is the power of knowing your rights, and that is why Miranda matters. Not for criminals, not for cops, but for every one of us who values the Constitution and wants our choice, our words, to truly be our own.